A judgment, as it relates to bankruptcy, is a state court order that allows a creditor to collect on their debt by way of either judgment lien, when it pertains to real property, or levy of personal property, when you do not have real property. There are no assets, generally, that are judgment-proof. Any asset that you own is subject to levy, seizure, or lien when it comes to judgments. That is why it is so important to seek counsel from a bankruptcy attorney if you do receive any information on a judgment or a potential judgment against you. Judgments don't disappear. They can stay on your credit for a total of 10 years. And then the judgment creditor has an opportunity to renew that judgment for another 10 years. So a judgment can stay on your record for a max of 20 years. And the only way for the judgment to actually disappear is the expiration, unless you file bankruptcy or pay that judgment in full. Judgments in bankruptcy are treated several different ways. Unsecured judgments may be treated just like any other creditor, where they get a portion of a planned payment or they don't get paid at all. Secured judgments can either be deemed unsecured, where we can avoid that judgment entirely, or propose to partially or fully pay it. It all depends on your assets and what we can protect in a bankruptcy. If you receive a state court action that begins as a civil summons and complaint and moves to a judgment, it is always very important to seek counsel from a bankruptcy attorney. If you ignore those types of actions, they can either attach as judgment liens against your real property, which will stay on your property for a max of 20 years or until you sell or surrender the property. Or we can attempt to settle, pay, or get rid of the judgment in a bankruptcy. There are deadlines when you receive judgment paperwork from state court, so it is imperative that you meet those deadlines and speak to an experienced attorney to determine what your options are and how long you have to fulfill those options. Our firm addresses judgments in a large portion of our bankruptcy cases, whether those judgments are in the form of judgment liens against real property, whether they're judgments that have not yet been wiped off of someone's credit for that 10 to 20 year period, or whether they're brand new judgments that clients have recently received and trying to handle. But in all walks of that judgment period, a bankruptcy attorney can assist. When we help our clients either to stop a foreclosure on their home, get a vehicle back that they needed to transport to either medical appointments or work, or just stop harassing phone calls because they're keeping our clients up at night, that really does make us feel good. It makes us know that we're making a difference in these clients' lives, where if we can just help with that financial situation, that everything else in their lives can fall into place. Our firm is a small firm. Currently, we have 3 attorneys and a small staff. We all operate as a team, as a family. Some of our staff members have been with us for years and years. We believe that having a small firm allows our staff and our attorneys to have a personal relationship and a personal connection with each and every one of our clients. When a client or potential client sits down with one of our attorneys and discusses their financial situation, our attorneys listen. We are non-judgmental. We understand that life happens and things happen that are not always in your control with your finances or otherwise. Our clients come to us because we are able to assist with those situations. We are able to give them a solution and hope for a better financial future. If you take a look at our current online reviews, we have over 100 reviews from current and past clients, even from people that we have talked to that we have not been able to help, that have left us reviews because we were able to give them some sort of advice. Our reviews really speak for themselves. Communication, communication, communication. You will hear that tons and tons of times at this firm. It is our mantra. It is what our attorneys express to our staff members. You will get a phone call and email back almost immediately in most cases. Brand new clients usually get to speak with an attorney either right away or within 24 hours. Communication is very important in all attorneys' offices, but very important to ours. During an initial consultation with our firm, if you are experiencing harassment from a judgment creditor, we will look at the deadlines, we will review the court documents, and we will look to see what your options are, whether in or outside of a bankruptcy.